So, in the spirit of this day, I'm underprepared. Don't have prepared remarks, and I'd like to have this as a kind of conversation. I've just been sitting at the back all day. I haven't made any comments. I've been listening and trying to absorb and trying to make this into a coherent whole. I haven't succeeded, but that's okay. And I'd like to have a conversation and people to interrupt me as we've been doing the whole day, and try to kind of think about some takeaways. So I've got three kind of way of structuring this. I have three areas. One is I want to think about Unbound as a journal and today's conference as an example of the kind of management of the commons, and an example of the commons that we've been discussing. So it's trying to relate form and content somewhat. One, I want to think a little bit about the role of lawyers in social movements, in the commons, and in all of this. Many of the people you've heard speak today are lawyers or law students. And then I'd like to just think about some general takeaways from the conference. And as I said, all of this is not, I don't have a kind of a plan here or where it's exactly going to go, so I want people to jump in all the time. So just thinking about Unbound as a journal, first of all. We're a journal at Harvard Law School. We do things that other journals do. We publish a volume every year online. You can check it out at legalleft.org. We host conferences, which look a lot like other conferences in this room, which a lot of other journals do too. We try to think about our internal governance structures as being very different from other journals. We're non-hierarchical, for example. We have editors-in-chief because the rules of the state or the law school say you have to have an editor-in-chief. But we make all our decisions communally. We don't really theorize very much about what that means. We just kind of sit in a room and what happens, happens. And then I think in thinking about this conference, we've tried to undermine some of what is hierarchical about many conferences, while, of course, maintaining a lot of it. And I think this maybe speaks a little bit to what Duncan Kennedy opened the conference with, about how a lot of the decisions you might want to avoid end up going all the way down. And once you decide to have a kind of a communal activity, you're still going to have to make all kinds of political decisions once you get into that. So one of the structural decisions which we've made, again, a structural decision we made in advance, was to not ask for prepared comments from the panelists, but to give them either the burden or the delight of having no prepared remarks. I was maybe somewhat surprised by how many of the panelists spoke. I was doing a lot of the communication with the panelists before, and how many spoke to me personally about the burden aspect of this. I thought maybe we were relieving them of the burden of having to prepare, but actually many seemed to feel that it was going to be more of a challenge, and in some ways, of course, it is. And so I think this is an example of structuring a situation in order to, we made this decision hoping that we would get newer and fresher ideas by interactions, by people not knowing what they were going to say in advance. And that was a risk for us as the conference organizers because we had no idea what was going to be said, and it was a risk for the participants because they didn't know they were going to be able to stand up and say something, or sit down and say something interesting because they didn't know what they were going to say. It's less safe. And I think thinking about again, and remember, everyone's supposed to jump in whenever you want to jump in. I'm just going to talk until someone does. Thinking about the form of the conference as a kind of a gathering, I think, especially in the second panel, there were mentioned 4 different aspects of gatherings that struck me in any way, and I'm calling these imagining, delight, security, and the possibility of self-management. Those were ideas that came up several times, I thought. Imagining, delight, security, and the possibility of self-management. And within the discussion about imagining, the point was raised about a gathering creating the possibility of a left language, and imagining a kind of a critique of liberal language and liberal forms. And I think one thing that has kind of come up today, and especially in the third panel, but linking back to Duncan's talks at the beginning for me, about what is the possibility of going beyond just the realization of the plasticity of property as a bundle of rights, maybe. I think that brings me on, and I really do want people to interrupt me and say things. That brings me on to kind of my second set of things about the role of lawyers in social movements. And so, yeah, yes, great.
So can you say a little bit about the intention of the group in terms of form? Could you say a little bit more about the intention of the group in terms of content? Like, what were you all thinking about property when you chose the people who would speak, and what kind of things were you thinking about that? Is there any of or is the internal discussion of the group?
It's very much not secret. So I think one of the things we were thinking is about bringing together lawyers and non-lawyers in this discussion. You're an example of a non-lawyer. There are lots of examples of lawyers. So bringing in different perspectives and thinking about, we were focused, I think, from very early on, and the people, Derek especially, I'm thinking, should jump in and talk here, but about that first move that law can offer, about the plasticity of property as an example, and I think we could have picked another topic, but property, I think Carl mentioned this before, seems to have a role as, first of all, something that's been, and actually David Bollier mentioned this as well, as something that has such a long history in it, and a history of the debate about the ownership of private property in the commons, for example. So I'm in a course right now I'm taking at the government school called What is Property, where we're starting with the Bible and Plato and Aristotle and going through to Nozick. And there's about 2 questions that everyone in between them that we're reading, Augustine, Machiavelli, Hobbes, Locke, or whatever, all of those guys are answering, really kind of looking at just 2 or 3 questions, and you can describe a lot of their work in those terms. And so I think property, that kind of long history tied to what Carl was talking about the property is seen from kind of outside, and was talked about a lot in this last panel. Property is seen from the outside in many ways as being one of the most core areas of law that has the least plasticity. And of course, there's property law, and you own things, and it's simple, and those debates have all been had years ago, and it's all very, very straightforward.
So let me jump in just to dovetail on that point. Like, I think additionally, it's interesting that for something which is so fundamental to the way we structure our society, and as you're saying, has so many different nuances and aspects to it, it implicates so many different areas of the law, you'll always encounter property law in some capacity, and there's no real way to demarcate it and separate it off and say that it's any one thing. But for all of that, and for all of the ways that it manifests itself in our society, it strikes me, at least, as a highly depoliticized aspect. Most people don't think of property law as a state creation. They think of property law as maybe more along the natural rights kind of framework, but not in the sense that they're willing to claim their rights or claim something different about it oftentimes. But it feels like they treat property law as this fixed thing that we have to work around. And so even if we, on the left, have a political project, we think that all we can maybe attempt is to regulate after the fact in some capacity. But I think that there's, and I think this is completely consistent with the kind of indeterminacy Duncan Kennedy plasticity notion, is that we can actually just make slight alterations within property law that may or may not have helpful effects. And I think also just to think about the other interesting goal here is to unite people who are thinking carefully about the doctrine in a particular specific way with people who might be able or are trying to think about a broader vision, that even though it may not be that anything about the property law is coherent or really reflects a broader vision of anybody, yet I think it's still significant to consider what the visions of people who are involved in that process of manufacturing an area of the law, which ends up being quite disparate and fragmented, but the visions of the people seem to matter. People seem to think that an actual notion that's a broader construction can make change. And so that's just in the topic of bringing together people who are approaching it a little differently.
So I think, I think that's great. And one thing that I'm thinking about right now, in light of that last panel, I think there was some confusion about a lot of terms, and is about whether this was the right vehicle for that kind of thing we were thinking. I mean, we kind of had this sequence of the panels in a way of trying to have some broader theoretical ideas before and then translating them into property goals, but maybe that's not something you can really do in a conference with people sitting up. Maybe that would have to be, people sitting around a table, or maybe it would have to be people in Zuccotti Park sitting there for a month and doing that project, and there have to be lawyers in there, and maybe it's not possible to do that project by talking about some broad ideas for a while, and then by having property law scholars sit there and try to take a lot of different ideas that have been discussed and then discuss specific doctrines of property law, which I think brings me to my second kind of topic on the role of lawyers in social movements. And I think we've heard a lot of different kind of conceptions about what that might be today. I certainly don't have an answer, but I'll just throw out some of the kind of conceptions that I've heard. So one is going back to Duncan Kennedy's kind of tool thing. Is the role of lawyers just to translate a movement's goals into an institutional reform project, maybe of specific laws or specific doctrines? And another way of thinking about that might be an idea that came up in the first panel of reconfiguring the state's relationship to the commons or the state's relationship to a movement. Maybe lawyers are just supposed to be managing that interaction to allow the space for the movement to develop, and then taking whatever develops in the movement and trying to apply it to manage more space. Is the role of lawyers just an explanatory role, explaining what tax increment financing is? Do the lawyers have a role in constituting the movement? So the grant of eminent domain to build cooperative housing to this organization, that presumably there were a lot of lawyers involved early in that stage, and the movement would not have existed without the lawyers coming in at the early stage. And I think Zuccotti Park is another example where there are a lot of lawyers making the decision to choose Zuccotti Park over other sites for very specific reasons of law. Is the role of lawyers to create a blanker slate for the movement by defetishizing existing law and just stating this plasticity and then getting out the way, saying you can do whatever you want in property law, so let's just let me explain that to you, and then I'm going to step out of the way and you decide what you want to do, and then maybe I'll come in again at the end. Is there a role of lawyers in the rhetoric aspect of it? And this is kind of the link to neoliberalism, which has been floating maybe undefined throughout this day, in undermining the idea of property law as fixed absolute private ownership, and showing that there are other options there. Maybe undermining the neoliberal conception of property law, whatever that means, and undermining the power of that rhetoric to prevent people from thinking about alternative options and conceptions. So unless anyone's going to jump in there, I'm going to move on to the third thing I said I was going to talk about, which is takeaways, and see if anyone has any either kind of ideas or substantive ideas they want to raise that they think have come to them or seemed especially prominent to them today through the conversations we've had, or ideas about how to continue the conversation. Which questions should we continue to ask? How should we continue to ask them? Again, and I can't resist a little plug here that Unbound publishes a journal every year. It's online, so it's completely open in form. You could publish a law review article with us, you can publish a poem with us, you can publish a paragraph, you can publish in bullet points. We don't publish everything that is submitted to us, but we will publish in any format. We have no rules about what kind of things we publish. So that's one way that this conversation could be continued, but what other ways could there be? Yeah, Becca.
I just have another question, which is something that I think came up in almost all the panels that a lot of people seem to be interested in, but nobody really talked about, is the sort of codependency of the property regime on the family. And I think that is something that would be really interesting, because to me it seems like there's no destroying the property regime without also getting into the way that the family necessitates it and properties. So is the family this private tyrannical zone because we all have to own homes, or do we have to own homes because we all have to be in families and raise babies? So sort of which one perpetuates the other, and I don't think that we can get rid of one without destroying the other. I don't know which has to happen first.
Was that a question for me or I saw some other hands up before.
I think I'm going to reflect a lot on this this issue of kind of how of framing, and it seems like in some ways we put the property law scholars a bit on the defensive, in an interesting sort of way. But the title wasn't abolishing, for their panel wasn't abolishing property or even new forms of property. It was new property relations, which I think is well within the framework of what legal doctrinal scholars are talking about. But then what's interesting to me is when we're talking about the family, and so that same insight of like, okay, maybe we can reframe it in a way that feels like a constructive reframing. So maybe we kind of have to think about that as well with the family. It's like we're not trying to tear apart the family. What kinds of possibilities of human relations are we trying to open up here? And I think you could do the same thing with property. Not to say, like, I'm also nervous about really entrenching it further, but you can kind of think about, okay, what kinds of new property relations, opportunities are we going to be able to create, and that can be, I don't know, keep people more in your project.
Right, and I really like the idea that I forget now who, I think maybe Michael Hart raised it, but about us conceptualizing love and family relations in terms of ownership, and in Hebrew there's Dodi li v'ani l'dodi. I am my love, and my love is mine. Like ownership as a kind of the conception we have of a love relationship, and I think that may speak to something that the organizers, were thinking about in terms of neoliberalism. This as again going back to Foucault, of neoliberalism as this generalizing of market relationships into as many spheres of society as possible, and that's kind of an additional sphere. Unless anyone else has any final remarks, we've hit and surpassed 5:30. So my main two final things I'd like to say. One is a tremendous thank you to all of our panelists and all of you in the audience. I tremendously enjoyed today. I had a great time, whether anything comes out of it or not. I had a great time. So thank you really for that, and for being willing to take the risk of coming without any prepared remarks and engaging in this minorly subversive project with us. And the one thing I'm sure about how to continue this conversation is that the conversation will continue imminently over drinks and food in Westside Lounge, which is just up Mass Ave, 1680 Mass Ave. We have a big budget, so come and get cocktails and pizza and whatever else they have there. So enjoy. Thank you.